18-1-444-34, case 18-1-447-34, and case 18-1-545-34. And if possible, I'd actually like all of the attorneys to come forward, and the parties if they wish, because there are several issues that I think we just need to deal with in all of these cases at the same time.
And the parties and the state spoke prior to court, and
I'm sorry, I just want to start with appearances.
Yes, Sharon. Heather Stone on behalf of the state of Washington. To my left is Ms. Olivia Zoe, also on behalf of the state of Washington.
Angela Blatt on behalf of Mr. Michael Flynn.
Peter Simpson, Frank Lee.
Kelly Seager on behalf of Matthew Franklin.
Christopher Swayze on behalf of the defendant named in State versus Canton.
Thank you. And so,
the record show I'm appearing specially not generally asked,
sir.
authorized representative agent for the principal, Lou Ken, under protest, threat, duress, and coercion. And I reserve my rights and remember at all times.
Please don't interrupt these proceedings again. I asked the clerk to call security. I just want to tell folks that you're all represented by attorneys. Each of the defendants are represented by attorneys, and I will be addressing each of these cases by those attorneys. If you have any questions, please ask your attorney after these proceedings, or your attorney can certainly ask for a break during this hearing so that you can have a conversation with your attorney.
Let the record show that I'm appearing specially and not generally as an authorized representative agent for the principal Quinn Michael. And the threat, protest,
You have to slow down.
It's okay. You know
and I
what?
reserve my right to litigate at all times.
Once again, if your attorneys request it, I will give you the opportunity to be heard on the record. This is not that time. So I'm going to ask you all to just refrain from speaking on the record at this time unless your attorney makes that request on your behalf. I've started just with appearances on the record. It appears that all of the attorneys are here representing their clients, the defendants. The defendants are present. And I'd like to begin with some preliminary matters. Again, if you wish to be heard on the record, please ask your attorney to make that request on your behalf, and that can be done at the end of these proceedings. Ms. Stone.
Yes, Sharon, thank you. As I understand it, each of the attorneys through their clients now are requesting, each of the defendants through their attorneys are requesting bench trials. If the court is willing to grant that, that may address many of the motions in limine as being moot if the court grants that request from the parties. So when the parties discussed, we thought that may, as a preliminary matter, be, the court may want to address that first, as it may be dispositive of some of the other issues.
That may or may not be true. I know that in at least one case, issues were brief as to whether it's a bench trial or a jury trial, but I cannot believe that that would make most of the issues go away. There are still some significant evidentiary issues, at least that I've briefed. And what I'm most interested in is agreements by the parties with regard to evidentiary issues. However, if it is the party's preference to address this issue of potential bench trials, I will address that first if you wish. So I'll ask the defense attorneys specifically for your case whether that's something that you think it might be helpful to address first. Ms. Palmada?
Your Honor, I'm happy to address that first.
Do you think that's best to address first?
I think it could potentially be helpful. I don't know if it's entirely as dispositive in my case as Ms. Stone represented, but I'm not aware of the other cases, so I can't speak.
Okay, I'm just asking you about your case, Ms. Collada. In your case, do you believe that your client wishes to waive a jury trial?
Yes, Your Honor, that is my understanding.
Okay. And so I'll ask each of the defense attorneys that question. Mr. Smith? And you're here for Defendant David Lee, correct?
It is our intention to file a waiver of jury trial. And we get the dispense with this first part of the benefit proceeding. So I agree with this.
And have you filed such a pleading?
I have it in my case.
Excellent, thank you. Mr. Sweeney? Do you need a moment, Mr. Sweeney?
Thank you, Your Honor. And a request has been made previously by the person I represent to have a bench trial. The wording of the request that I made in writing is something we were discussing. He has some concern about my use of the word waiver. But it is my understanding, and we met late last week, he is insisting upon a trial before the bench.
So, as your understanding now is that your client wishes to proceed on a bench trial?
Yes, and he has said that repeatedly. My concern, Your Honor, is finding wording that addresses that in writing so that we have a record.
I understand that. I'm not addressing that right now.
Okay,
I'm going to go through with each of the defendants, if that's the plan, to address waiver. And that word is very important to the court. And not only that, but as I indicated to you at the last hearing, even if a defendant waives that right, it is still the court's decision whether to proceed with a bench trial as opposed to a jury trial. So we will address those. I'm really just trying to understand what the preference of the parties is first, and then we'll address those individually.
I think I understood, Your Honor, and I appreciate the explanation for those who might not have understood.
Excellent. Ms. Seto?
I met with Mr. Tran last Friday. I've spoken with him today prior to court. He wishes to go forward with the bench trial. We have not addressed any issues about waiver or language.
Thank you. Mr. Simpson?
Thank you, Your Honor. Ms. Lee has indicated her preference would be to waive the right to a jury and to proceed with the bench trial alone with this court. And I do have a proposed waiver of trial by jury and consent to trial by judge alone. As to the way that this afternoon's hearings would proceed, I believe hearing this first would assist.
Thank you. Those preliminary comments are very helpful to the court in determining sort of where to go from here. I think I mentioned at the last hearing, I was concerned that perhaps some but not all of the defendants might be interested in a bench trial, which would be difficult for the court. If it is the preference of each of the defendants to proceed with a bench trial, then the next step that I would like to take is to make sure on the record that we have a clear understanding that each of the defendants has knowingly, voluntarily, and intelligently waived their right to a jury trial. Now, the reason I say that is because they do have a right to a jury trial. I know all of the attorneys know this, and they fully explain this to their clients. I have no doubt that those conversations have occurred. But I want to be assured of that, and I need to make sure that the record clearly shows that there is a waiver on behalf of each of the defendants before the court exercises its discretion in the decision to grant that motion for a bench trial and accepts that waiver. It appears to me that, at least for some of the defendants, a little bit of time might be helpful to make sure that the defendants explain to each of their clients that the court will be asking about whether that waiver is knowing and voluntary. The assurance of that waiver can be written, it can be through the attorney for the party, or it can be through a direct representation by a party. So I leave that to the attorneys, who hopefully have had the opportunity to fully explain to each of the defendants the rights that they would be waiving in requesting a bench trial. So my proposal would be to have a short break to ensure that all of the attorneys representing the defendants have the adequate opportunity to have that full conversation with their lawyers. And then go back on the record. Do the
State
attorneys-
has no objection to that.
The state has no objection to that procedure. Do the defense attorneys have any objection to that procedure or require any further clarification?
I do not.
No, Your Honor.
No, Your Honor.
No, Your Honor.
No, Your Honor.
And so my plan would be to have a break for about 10 to 15 minutes. If more time is necessary, I would ask one of the defense attorneys to just indicate to the clerk that more time is necessary. I'm hopeful that that's enough time, but it might not be. So we'll be in recess for about 10 to 15 minutes. If you could indicate to the clerk when you're ready to go.
Thank you, Your Honor.
Thank you very much.
All rise.
May I address the court, please?
You may.
Your Honor, during the time that you gave us to talk to our clients, we noticed that there was someone in the hall speaking with our clients, and it appeared that this person was giving our clients legal advice. It's not the first time we've seen it. The concern that I have, and I believe it is shared by all of the defendants' lawyers, is that our clients have been getting advice that is in some ways inconsistent with the advice that we have been giving them about how to go forward. This has continued, and I think it's come to a head now that we are just 5 days, I guess, from trial, Your Honor. And it's created what I think we would all call potential for a rift in our relationship. I think it's already created a rift in my relationship with my client. And I am concerned, as an ethical matter, about going forward representing my client when my client has evinced continuing concerns about his representation by someone who is being paid in his mind by the same people who pay the state. And when my advice is not being listened to or heeded, and I don't know that maybe the reverse is what I should be saying, that in going forward, I don't know that I am going to be adequately representing my client's interests, because I, as a lawyer, know what I should be arguing in this case, and it is not consistent with the advice he has been getting. It's my understanding that there are witnesses to these conversations who have more detail about what was said, Your Honor, and I offer this not meaning to get those people prosecuted, but to suggest to the court that right now the court needs to be aware that there is a real substantial divide, at least between myself and the person I represent. And I think that I'm worried about going forward representing that person when it is clear on a number of levels that that person does not seek my representation. Will not be
So I'm gonna cut you off
I'm
there.
sorry.
I've let you go on for quite some time.
Yes, Your Honor.
I'm hearing, perhaps, Mr. Swaby, that you're not ready to proceed with the colloquy on waiver of a jury trial at this time. That's what we plan to go forward with?
Yes.
And instead, what I am hearing is that your client and perhaps some of the other defendants in this group of cases that are set to be tried together starting on Monday have been receiving advice from someone other than their lawyers. Frankly, that's not unusual, and it's not unusual for an attorney to get input either from their client directly or from a family member or someone else that is inconsistent with what their lawyer deems to be their best interest or inconsistent with their lawyer's advice. I'm not saying that's what we have here, I'm just saying that we know that that happens from time to time. I also know, because I'm familiar with the history of these cases, that the relationship between the defendants in some of these cases and their lawyers in some of these cases have been difficult for various reasons. I appreciate that. I also appreciate that the lawyers that are assigned to each of these cases have, in my view, in front of me, in open court, done a very good job attempting in all cases to represent their clients well, to pursue their clients' arguments, whether or not they are consistent with the attorney's advice. And the attorneys, the defense attorneys before me, know very well their obligation to their client. And in my view, of course, having nothing to do with any conversations between the defendants and the lawyers, but in my view, in open court, the attorneys have done an excellent job of abiding by the court's procedures and advocating for their clients and making arguments on behalf of their clients in all cases. So with that said, I don't know if this conversation is some sort of attempt to make a motion to either delay the trial or to withdraw, but I'm not hearing any of those at this time.
I'm making a record. Should there be a conviction in this case, Your Honor, explain to the court where I believe we are today, at least between myself and the defendant named in State versus Canyon Lee.
Very well. And I always sort of question when I hear a lawyer say want to make a record, because that tells me that there's maybe a request out there that the court should be concerned about or be deciding, or and I don't have one before me, so I'm concerned about that. For instance, I have lawyers all the time say, you know, if I say, are you done with your argument? They'll say, well, I am if you rule in my favor, but if you're thinking of ruling against me, I want more time.
Yes,
That's right. So I don't know if this is one of those situations, but we have a lot of things we have to cover this afternoon. So if you have a request, let me know what that is, but we need to move forward.
I understand the court's concerns, I understand the timing issues, and Your Honor, because this has come to a head right now, what I know is I felt I needed to make a record. I don't know what the motion is, I don't know what my request would be. It may be, I know it's 4:30, 4 o'clock, as we're addressing these things, because I'm having to think it through. In year 29 of my practice, I have never come up against this. So I don't have a ready answer for you, and I'll keep talking if you let me, so why don't I move away from the podium and let somebody else address this?
Okay, once again, we're back on the record to address the issue of waiver of jury. And Mr. Sweeney, I do need you back because you started first. I'll grant you. I presume by your comments that you're not prepared to go forward with a waiver of jury trial, and therefore will proceed on a jury trial.
My client has evinced to me on no less than 5 occasions that he would like this case heard by a judge. Your use of the word waiver is problematic to him. He does not want to waive rights, but he understands that he can make the choice to go forward with a judge instead of a jury, and that's what he wants. I've explained to him that the court will use the word waiver because it's a legal term, and you have to, but he would, as I understood it 20 minutes ago, say that his choice is to go with a bench trial.
I'm sorry.
Did he sign a document? That I deem to be a waiver.
You don't want to waive a jury trial.
So
I
You
unless,
don't want it attributed to
do
you
a colloquy
directly.
with him when we address this.
You don't have to do that
Perhaps I
with me. You
haven't
can just
been
talk to me.
clear.
I'm not gonna attribute any statement to you. We have a
We
confidential
have
relationship.
many,
That
many
means I keep your
issues that we
secrets.
have to address this afternoon. One that I did not anticipate, because I reviewed all of the
Why are you
files
talking like
and
this?
saw no
Stop it.
reasons.
Please
Was
stop talking
a
like
waiver
this.
of jury
I can't
trial.
talk to you like
I was
this. I just
told
need
at
you
the
to tell me
beginning of
what's
this hearing
happening. You want me?
that the defendants are wishing to proceed on a bench trial and waive jury trial. I was willing to give the parties some time
All right,
to address
I'll raise the issue to the
waivers.
judge, but I'm gonna alert the judge to the fact that I can't
And-
get a straight answer out of you.
I'm hearing we're still
I think the judge
approving.
is likely.
If your client does
understand
not
that.
agree to the
But you
term
can
waiver, which
reiterate.
is a really important word, and I know that you've explained to your client
I
what
will raise
that
it with the judge, and the judge
means.
is gonna inquire with you.
I'm not going to
I'm gonna
take
raise it with the
an
judge. If I
hour
can't get a
in
straight
each
answer, the judge is
case
gonna want a straight answer directly from
explaining
you.
what I know you've already explained. I want to have an understanding that your client
I don't understand what you're
waives
saying.
his right to a jury trial, that he understands what that is,
So, you want a bench trial?
and that he's willing to
waive
do that.
anything.
The fact that he's not willing to sign a written waiver
And you don't make
causes me
any of the
enough
statements
pause to not
attributed
go forward
to
with that today.
you directly.
Correct.
You said.
Especially in light of the fact that it appears other defendants have done so.
Thank you.
So I'll address the other counsel.
Thank you.
Ms. C.
Well, Judge, Fred, I have some of the similar situation that Mr. Swayze has. My client, Matthew Tran, I would ask that he be questioned by the court, or I could question him very briefly as to his intention. He's indicated unequivocally that he wants a bench trial. I've explained in an hour-and-a-half meeting with him prior to this last week what that would involve, and that a waiver would have to be signed, and that jury trial is his right. He takes objection, and I think this is where what Mr. Swayze was making a record of. Other individuals, just in the time since we walked in this courtroom to the break where he was left unattended with individuals who have given him other legal advice, now doesn't wish to use anything and sign anything that has the word waiver in it, and wants to say reservation. I come from a jurisdiction in Illinois previously where I'm very familiar with doing bench trials. We do regular jury waivers. I am not comfortable going forward to a bench trial if he has not signed a waiver as the court has requested. So he has indicated he wishes a bench trial. He has also indicated, based on advice that is not his lawyer's advice, that he will not do the requisite events, i.e. sign a piece of paper saying I give up my jury, I understand what a jury trial is, and I give up that right, and I wish to have a bench trial. So his wish is a bench trial. He will not do the requisite items, and that's where I have to leave it to the court.
Thank you. Mr. Simpson?
Yes, Your Honor. And, Ms. Lee, would you want to come forward? Or not? Did you want to come forward with me?
I'm the agent, it's not my case, so go ahead.
Okay. Your Honor, I've had an opportunity to discuss this issue with regards to the waiver of a jury trial and proceeding to a bench trial. With my client, we've talked about it multiple times, having an opportunity to explain to her, and even going farther into it, sort of trying to explain the historical basis by the reasons for the jury system, how important they are, and how important the constitutional right to a jury is, that you're entitled to have a jury of your peers, people from the community, to come forward and decide themselves the ultimate issue. In talking with her, we went over a document. It is titled The Defendant's Waiver of Trial by Jury and Consent to Trial by Judge Alone. However, she did indicate to me in our discussion that she does not want to waive anything. She wants to decide to have a bench trial. But the language that we would propose is that the trying by in person and represented by her attorney of record, Peter Simpson, with full knowledge and understanding of her right to a trial by jury, and does hereby consent to a trial by judge alone without a jury. I am knowingly and voluntarily exercising my right to a bench trial. So that's what we would have to present to the court today. And that is in keeping with my discussions with Ms. Lee, and in respecting her wishes to hopefully, at least in some respect, work with me to make sure that we're as successful as possible here today and going forward.
And so your client isn't willing to say that she waives her right to a jury trial?
Well, we went over it a couple of times. I guess the straight answer would be no. Although we do have this document where the caption is a waiver, but in talking with her again, it's more so her decision to want to proceed by a bench trial.
What's your understanding of that distinction?
I guess I would say it's probably along the same lines as what you've heard from other counsel, that there is simply that the defendant does not want to waive any rights.
And you've described to her that she would be waiving rights.
Yes, I told her that this court is going to expect a waiver.
And she does not want to waive those.
What she wants, her to answer that question. At the same time, she does not want to enter into a waiver of any rights, but she wants to proceed with a bench trial.
Thank you.
Did you want to have me hand forward any signed document this time?
You can file whatever you wish, but I'm not stopping you from filing a document. Ms. Collada?
Good afternoon. Your Honor, I would like to echo some of Mr. Swayze's comments. However, I would like to explain myself a little bit differently. The purpose for when I make a record without making a request is because I don't think I'm there yet or have enough sufficient basis to make a request. But I want to sort of put a place marker in the record to indicate that I've recognized that this is potentially a problem, but it's not yet risen to the level of being something I'm asking the court to affirmatively address. And so that's what I'd like to do in this instance. I do believe that there are potentially obstacles to my interaction with my client and my ability to effectively represent him.
I'm sorry to interrupt. Tell me what I can do now to address those obstacles so that it doesn't become an issue. Because we're starting trial on Monday in this case, and I want to do everything that I can to help the parties get ready to start this trial on Monday.
And I don't know if I can ask for, or if there's a basis for the court to take the action that I would seek. I would seek the court ordering that at least there's a individual who is in the hallway who I don't believe is in the courtroom right now to not give legal advice to the co-defendants in this case. I don't know his name. I can't identify him if necessary.
So, I'm sorry, go ahead.
Of course. But Your Honor, that's all I could ask for now. At this point, I am just asking to make the record so that I have the placeholder, so that should this get to a point where I don't think I can work around it, I can re-raise it. Otherwise, I'm happy to move to the waiver of the jury trial if the court's willing to.
So I have a question.
Yes, please.
Maybe this is the right time. Help me understand how this situation is different than a situation that occurs in many cases where a defendant is either not following the advice of their attorney, not agreeing with it, asking them to do things which the attorney disagrees with, or taking the advice of a family member, non-lawyer, or some family member lawyer who doesn't know the case well, but who they're listening to. That occurs fairly frequently. I'm not understanding why this is different here.
And Your Honor, I'm not sure I can fully answer that question without potentially divulging what our still client confidences.
And I appreciate, I don't want you to do that.
But if I may attempt to speak in generalities, they may be unsatisfying, and I do apologize for that. I think the distinction here is that conceptually, some of the disagreements are not based in reality, and are not an actual or practical understanding of what is legitimately the law. So as opposed to a family member who might think, I want my child to go to trial, or I want my child's plea when I'm advising for something the opposite. This is something where the other option is an option that doesn't exist in reality, if that makes sense. And it is, it's hard to argue with things that are imaginary, for lack of a better way to put it.
And I appreciate that. I'm just trying to think in my role, what I could do to address this concern that the attorneys have raised. It occurs to me that all of the defendants in these cases are represented by competent lawyers. So I don't believe that assigning different lawyers would make any difference. All of these cases appear to be ready for trial, and it doesn't appear to me that any additional time in preparation for trial would make a difference. So, again, I'm kind of trying to figure out what I can do to make sure that this case stays on track with these challenges that you're facing.
I don't know that there's any, and I do apologize for not being able to say, Your Honor, I want X, Y, and Z, and here's why. That is my preference when approaching the court with particular issues.
Yeah, no need to apologize. I appreciate your response.
May I address the issue of the waiver of jury trial?
Please.
Your Honor, this is likely going to be significantly similar to the record you've heard from other counsel previously. It is my understanding that a person who represents Mr. Quinn is affirmatively seeking a bench trial, is unwilling to waive any right of any kind, including the right to a jury trial, but when given a choice between a jury trial and a bench trial, has affirmatively said that a bench trial is preferred. I do have, I attempted to get a signed waiver of jury trial. The agent or person who is representing Mr. Quinn made amendments to this document, and I'm happy to pass that forward so the clerk can review it or file it independently, whatever direction you see.
It's up to you. And so, based upon that, it appears to me that the waiver is a little unclear.
Your Honor, I would agree based on the court's standard of knowing intelligent and voluntary and actually having to affirmatively use the words waiver of a jury trial. I would agree.
Thank you. Mr. Smith.
Thank you, Your Honor. My situation is similar to what's been described by other counsel prior to me. Mr. Lee has clearly expressed a desire to have his case 18-1-0043-34 tried before a Superior Court judge. However, he does not like the use of the word waiver. If I can just, for a moment, I think it might be helpful to see actually what Mr. Lee has signed. I wish to bring this up. As you can see, he has crossed out the word waiver, and he has supplied other wordage there. And so,
Do you want the clerk to file this?
if I could have it back.
Oh, certainly.
It would seem to me said that it would be a discretionary matter with the court, whether the court considers that. But that is our situation. He wants to be tried by a judge. He doesn't like the use of the waiver.
Understood. I think that's fairly universal among the defendants. And I appreciate, again, that I'm sure that the attorneys have fully described to each of their clients that they have the right to a jury trial. And that right can be waived, and the court can have a bench trial. But it's very important, because it's such an important right to a jury trial, that the court understand that each defendant has been fully informed of that right and voluntarily waives that right. It appears to me from everything that has been said is that the defendants are fully aware of the significance of that term waiver and won't sign a document that indicates they're waiving. I don't know why. I don't know what the explanation is. I don't know if it has to do with this person who has been identified, who's been in the courtroom. But having looked at the authorities regarding waiver, if each of the defendants are not willing to say that they are willing to waive their rights, and they voluntarily waive their rights, I believe that their waivers are equivocal. And even if as to one or two, the attorneys feel, maybe the word isn't used, but I feel like we can be confident that what my client wants is to waive that right. At least one or two attorneys don't think that, and they agree that it's equivocal. And as I indicated before, we can't have a trial with some defendants being decided by jury and some decided by bench. We're not going to do it that way. And there's many reasons why, and if parties believe that it should be split somehow, or if that request comes up, I'll address that. But that's not what the court is going to do or plans to do. So, do any of the defense attorneys wish to be heard further with regard to the waiver question, or the jury trial, or the bench trial issue?
Do you want to address the court directly or no? Okay.
I don't have anything further on that.
My client is not indicating he has anything additional on that issue.
Nothing further on behalf of the defendant named.
So I will just state for the record that each of the defendants in these cases is in the courtroom, and it appears that each of the attorneys has conferred with their clients before answering the court's question as to whether they wish to be heard further on this issue. Mr. Smith?
I'm sorry.
Do you have anything further to offer?
No.
Mr. Simpson?
Nothing further, thank you.
Thank you. So we've spent quite a bit of time this afternoon attempting to address the question of whether this will be a bench trial or a jury trial. And after a lot of hard work on behalf of the defense attorneys and a lot of time spent by the court and the state's attorneys, it appears to me that if there is any waiver, and I'm not sure that there is, but if there is, that it is equivocal, and the court cannot accept an equivocal waiver of such an important right as a jury trial. So we're back where we started at 1:30. This is a hearing on motions in limine. We will proceed with those motions, and I would just ask all of the attorneys to approach the lectern, and so we can address, as I said at the beginning of this hearing, some agreed issues, and then we'll set a schedule for those contested issues that we're going to address this afternoon. So, the first thing that I'd like to address is that the state filed motions in limine. It appeared to me that none of the defense attorneys filed objections to the state's motions in limine. Now, that's often an indication of an agreement with the state's motions in limine, but not always. So I'd like to begin with the assumption that the defense attorneys, on behalf of their clients, agree with the state's motions in limine. And if any of the attorneys has an objection to any of the state's motions in limine, please indicate that now. Ms. Kamada, did you have something to say?
Yes, Your Honor. I did have a moment to confer with Ms. Stone about the state's motions in limine. I do believe the only issues that are potentially outstanding that may be future objections is the state's motion in limine number 4 about self-serving hearsay. I would object to this on the basis potentially of the rule of completeness. However, it depends on what the state seeks to admit at the time they seek to admit it.
Well, that's a motion in limine, so it's not what the state's evidence is. I think it's a motion to exclude.
Correct, and I believe it's the state's position that any statement elicited that was made by my client is potentially self-serving hearsay unless she is the person seeking to admit it. And what I'm saying is I object to that position on the basis that should she admit a statement attributed to my client, that I potentially have the rule of completeness as a basis to ask for more context or more of the statement to be
Understood.
Pardon me for not being clear.
That's okay. So, number 4, the state's motion says, no reference to defendant's self-serving hearsay statements to potential witnesses unless previously approved by the court via offer of proof. Is that something you could agree to?
Yes, Your Honor.
Okay. Because I think it takes into account your concern.
And I just wanted to be clear that that was a point of contention when I did discuss the motions with Ms. Stone.
Ms. Stone, is that your intention, that such statements could be approved by the court after an offer of proof?
Potentially, yes, Your Honor.
So I think with that, with the language of the motion, I think we're on the same page. Does that make sense?
It does, Your Honor, and I believe after other conversations with Ms. Stone that I do not have any further objections to the state's motions in limine.
Does anyone else wish to be heard on the state's motions in limine?
I do not.
No.
No. Your Honor, with regard to the state's motions in limine, I had filed a response. We may be covering it today, but originally, the state's request to bar the defense constitutional evidence and argument at trial as lawful defense. I don't know that we went through that issue completely at the previous hearing on the 28th, but in response to that, I did file a response that included...
When did you file a response?
The response was filed March 26th, and the reason I bring it up is just to let the court know, the court wanted me to talk to Ms. Stone about any type of issues that I raised there, and I did so, and I believe that we've come to an agreement with regard to the issue that I raised concerning using any type of language or other information that would be inflammatory or otherwise be more personal or attribute.
So my apologies.
I'm sorry, attribute what? I didn't hear the last thing.
Well, I stopped. I was thinking the court was... Well, that would... what I'm saying to the court is that I have had an opportunity to talk to Ms. Stone about that issue, and she told me that she would not be raising, and she can clarify this if necessary, would not be raising any type of issues with regard to the concerns I raised.
So, I'm sorry, I need to interrupt here because I'm just trying to make sure I've reviewed everything that I need to review to be prepared for these motions. So I indicated that I didn't see any responses or objections or opposition to the state's motions in limine. The state's motions were filed on April 3rd in each of these cases, and I didn't see a response. You indicated you filed a response in March?
Well, Your Honor, I guess the way I understood coming into this hearing is that we would be addressing not only motions in limine, but this issue raised by the state to bar the defense from any constitutional evidence.
So that's not what we're addressing.
Okay.
I'm addressing what's been briefed for this hearing only.
Okay, my apologies.
And I didn't see any briefing on that issue. I know that it was raised before. I asked for specific briefing on any issues regarding evidence. I didn't see it in these additional briefs. Perhaps we want to address that at the end of this hearing if that's something everybody else thinks needs to be addressed. I thought we addressed that last time by saying that it wasn't specific enough for the court to really make a ruling. But that's not what I'm talking about now, so my apologies. I was talking about the state's motion limine that was filed on April 3rd.
And Your Honor, I didn't file a written response to that, but I can let the court know as to the state's motions in limine. Numbers 1, 2, and 3, I have no objection. To number 4, I would concur with co-counsel Colloquy that no reference to defendant self-serving hearsay statements to potential witnesses unless previously approved by the court via offer of proof.
You're in agreement with that?
In agreement with that.
Okay.
As to number 5, 6, 7, number 8, number 9, and number 10, no objection. Number 11, I think I would ask the court to reserve that, reserve ruling on that, just based on the nature of this trial, the 6 co-defendants. I think it's sort of uncertain at this point what the nature of the individual evidence will be against my client, as well as individual evidence that may be presented that's more collective as to the group. And so I just ask the court to reserve until that issue may come up at trial. With regard to number 12, speaking objections, again, I think I would ask the court to reserve on that as well in the context of trial. Sometimes it does become necessary to offer the court a little bit more information as to the basis of any objection. Whereas I wouldn't want to step forward and just automatically decide to offer speaking objections on a regular basis, I think I would just ask the court not to rule on that, but to take it on each individual objection.
So, the purpose in the court setting a briefing schedule for this hearing was to avoid spending time at this hearing hearing that someone had no objection or what that objection was when the opportunity was there to file a brief. That's always my expectation when I set a briefing schedule, so that we start a hearing with the understanding of what's contested and what isn't. So we have a limited time this afternoon, and we've just spent a bunch of time listening to you tell me what you agree with and don't have a problem with, and then some argument. I'm hoping that in the future we can be more efficient with our time. So what I heard was that with regard to 2 of the state's motions, you agree with them generally, but you want the opportunity to bring it up later when it's maybe in context.
Yes, Your Honor.
I think that caveat applies to all motions in limine, and so I think I can incorporate that caveat with the court's ruling. And I don't believe anyone else has any objections, is that correct?
No objections. We've covered everything here.
Okay, so having heard from counsel, and I think clarifying some of the agreements of counsel, many of the state's motions are general, so I would anticipate that if something did come up, or any of the parties anticipate that something might come up, that will address it in the course of trial. I fully anticipate that all of the attorneys in this trial will follow the rules of evidence and will bring to the court's attention anything that they think might be a contested issue outside the presence of the jury, so that we can address those before the witness brings up whatever testimony or a characterization that an attorney is concerned about. Does that make sense?
Yes, Your Honor.
Yes, Your Honor.
Yes. Okay. So with those caveats, the court is granting the state's motions in limine, and the parties now need to.
Your Honor.
What?
I am so sorry for interrupting. It appears there's some defendants that left the courtroom, and even if they're not sitting here with us, I believe they should be in the courtroom while we discuss these issues. So I wonder if the court, I know we spend a lot of time not doing what the court wants us to be doing. Could we stop for a moment and see if we can't get those people back in?
You may.
Judge, along those lines, I would really ask that the court assign the defendant some spot in the courtroom that is not
So
in the mix.
we need to not speak while people are out of the courtroom, so we're just going to take a brief break from the record.
Yeah, yeah.
Can't do that. Or we'll take breaks.
So are we ready to go back on the record?
We don't have all the individuals back yet.
I
Bathroom,
have to
Your
assume that they left voluntarily, if they left, unless someone needs to make a record of some other thing. We need to proceed with this hearing. I think everyone knew we were going to proceed with this hearing. It may take until 5 o'clock. The attorneys are here to speak on behalf of the defendants. I don't, unless there's someone who's telling me like somebody had to leave because they were ill or can't proceed with the hearing, I'm assuming that anyone leaving the courtroom had to be done voluntarily.
Yes, Your Honor, but if we were in trial and we were sitting there in front of a jury, surely the court wouldn't, we wouldn't proceed if a client just got up and left the courtroom.
Well, I don't know if I would agree with your hypothetical, but in this situation, we started this hearing at 1:30. Frankly, it's not out of the question that someone would need to take a brief break. That occurs from time to time. I assume that all of your clients have decided to sit where they have sat in the courtroom, and I don't have any reason to think that this proceeding needs to end at this point, or we need to stop it. Mr. Swaby, do you have some information?
It appears that person walked back in, so I believe all of the people named as defendants are present in the courtroom as we speak.
So we are going to proceed with this hearing.
I apologize, Your Honor. I wasn't suggesting we stop.
Okay.
Period. I just wanted to go and get that person and bring them in here. I want my client to be present for all of these matters. Thank you.
Indeed. So it is my hope that all of the defendants who are in the courtroom right now remain in the courtroom, but I don't know, I don't know what more I can do.
Thank you.
Judge, I would request, and if the court can grant or not grant, I would request, this is a formal proceeding. I think this is part of our problem with the breakdown with communication with our clients and the information they're receiving from an individual who's not a party here. I believe that if this were one person proceeding, the court would certainly not allow the defendant to sit and talk with other individuals in the courtroom or not be in a designated area. I think that all the defendants should be at least in a designated space, and that anyone in the courtroom should be instructed not to interfere or discuss anything with them while this proceeding is going forward. That's what I'm requesting.
And I appreciate that request. I know that this has been difficult for the attorneys and frankly for the court, but I'm denying the request at this time. I am denying the request without prejudice, which will allow any party or attorney to make a request again, and we will have hopefully an opportunity to address that request before we begin trial, or even before that if necessary. I appreciate that request, and I think it's helpful for the court to be offered different options. And that's an option that the court will certainly consider. Even though this request is only being made once and being denied at this time, the court will very seriously consider that request and any other request in order to really manage this multi-defendant case and the difficulties that counsel have had. So by denying the court request, I'm not indicating that the court isn't open to options to make this case manageable for the attorneys and for the court.
Thank you, Your Honor, and as we're still in the motion to eliminate section, I would make an oral motion to eliminate that we do something to that effect, some designated seating that is not part of regular audience when we proceed to trial. And I could put that in writing and discuss whether the other attorneys, if that would be helpful to the court.
I appreciate that, and that's a great suggestion. I would encourage the attorneys to look at options collectively, because frankly, no matter what, we're going to have to manage the people in the courtroom. For instance, the configuration that we've got going right now, while it's very helpful to me, is not going to work very well with the jury. So I think it's really helpful to think about the courtroom dynamics, especially during jury selection, with all of the defendants and all of those moving parts. So to the extent the attorneys can talk about options and make either a joint proposal or a couple of options to the court, I would very much appreciate that.
And to that, and does the court know if we would be in this courtroom for trial or if we would be in maybe 102, a bigger courtroom for trial?
My understanding is that we will begin this trial in courtroom 102, but that may be limited to maybe 1 day, maybe 2 days, but it would be very limited. And we have multiple other matters that also require that large courtroom. And I'll just make a record here of something that I know all of the attorneys before me know, is that our space in this courthouse is unfortunately very limited. All of our courtrooms are used every single day by multiple litigants, and this case is just another indication that we don't have enough room on a regular basis for all of our matters. We only have one large courtroom, so we will be using that large courtroom for as long as we absolutely need it. But I'm hoping that it might be as limited as 1 day, and then we will need to give that courtroom up for likely another trial, which will need a very large jury pool for 1 or 2 days as well. So I'm not sure how that's all going to be managed, but I want to let the parties know it is my plan to have the large courtroom at least day 1, but then we will certainly move to a smaller courtroom, depending on the needs. And day 1 means that we'll get it first, and whatever other trial needs it, we'll have to wait till we're done with at least that large courtroom. I don't know if that helps.
It does, thank you.
So, after addressing that issue, and I know we haven't addressed it fully yet, I'd like to move on to some other motions in limine, if that's okay.
Yes, please.
Okay. So, there is a motion in the 442 case, Ms. Tolada's case, a motion to suppress. I believe that that is the only case in which that motion is made. Is that correct?
That is my understanding.
Ms. Stone, is that correct?
That's the state's understanding, Your Honor. It's the only one I received it.
Okay. I'm going to hear brief argument on that issue, and I'll ask the other attorneys to step back, but I want you to have the opportunity to be heard if you have anything to say, even though this is not an issue about your case. It is about the evidence in this trial. So I'm going to hear from Ms. Collada, then Ms. Stone, and if any of the attorneys have anything to add, I'll hear from all of you. This is an issue that has been briefed fully. I don't anticipate more than 5 minutes of argument for each side. You might not even need that. Ms. Collada.
Your Honor, I would largely stand on my briefing on this particular issue, but I would like to draw the court's particular attention to the potential policy implications of the decision making. Pretrial services is something that we use throughout the criminal justice system here in Thurston County to support the release of people from custody. If pretrial services questionnaires are going to start to be used against criminal defendants, I know that I will have no choice but to tell my clients to basically not participate, which makes this function of the court not function. And I think it serves a really important role here. You know, I don't think any of us, and I don't need to necessarily speak on behalf of my co-counsel here, but I don't think any lawyer in this courthouse who defends criminal defendants ever anticipated that a pretrial services document would be used against a client at trial. And that is a distinction I'm drawing. I'm specifically asking the court to find that this isn't appropriate at trial. I've given the court a number of ways to go about doing that. I'm not suggesting that pretrial services information can't be used for other purposes, such as revocation of conditions of release or for an increased bond amount. I'm saying at trial, when it isn't truly self-incrimination.
Thank you. Ms. Stone.
In response to that, Your Honor, as policy concerns are not a basis for suppression, there's nothing literally in case law or in the citation by counsel to support that. Moreover, I wholeheartedly disagree with the description that has a chilling effect. Regularly, Ms. McIntosh has people that don't participate. In fact, there's co-defendants in this case who have not participated in providing any information to pretrial services. And the directions that they're given are exactly the same. If you don't have an address, if you don't have a phone number, then we will send your mail to general delivery. If you don't have a phone number, as many of our transient population, then call in from wherever you are. As long as you call into us, you're fine. We'll make a note of where you've called from. But outside of that, you don't have to give us anything. So quite plainly, the description provided by counsel is just not accurate. Moreover, it's not supported by law for a basis of suppression. So I would ask the court to deny that request, and I would rely on the state's briefing in response instead.
Thank you. The court is granting the motion to suppress. The court is concerned about the constitutional rights of the defendants in these cases in which they provide documentation to pretrial services. In this case, it appears, and I'm only relying on Ms. Collada's motion, it appears that the state wishes to rely on a document that was in the files of pretrial services for essentially what appears to be an element of the case, that this person's phone number was associated with the defendant. And the providing of the information to pretrial services was something that occurred after these proceedings were initiated, after probable cause was found, presumably after the state had gathered at least some amount of evidence in this case. And the charge here is not associated with pretrial services activity. So in other words, if this was a case of witness tampering or something that arose after the initial charges, or if this were a case where the court was considering a modification of conditions based upon pretrial services activities, we might be in a different situation. But I do think it inappropriate for the state to rely on pretrial services forms for essentially their case in chief and the identity of that phone number and associating it with a particular individual, the defendant in this case. The court is also concerned, as raised by Ms. Collada, whether the defendant indeed provided that information. It is not apparent from this record that the information was actually provided by the defendant. It's such that it can be deemed a statement or information provided by the defendant. it appears that it might have been provided by someone else. So for all of those reasons, the court is granting the motion to suppress the pretrial services questionnaire and any testimony of Ms. McIntosh relating specifically to that questionnaire. Do the parties require any further clarification?
If I do, Your Honor, then one of the additional issues, because as the state understands it, the motion is only as to the pretrial services questionnaire. Ms. McIntosh would also testify that Mr. Quinn called in from that number, which is not associated with that pretrial services questionnaire, to do his reporting, and that she makes note of that number at the time that that call comes in. So as I understand the court's ruling, it's only to the questionnaire, not to Ms. McIntosh's interaction with Mr. Wynn.
Well, since that wasn't before me, I don't know.
Yes, Your Honor.
I reviewed the motion, and I don't know what level of detail that was addressed by the motion, and if that was a detail that I missed, I apologize.
Your Honor, I wasn't actually aware until a very recent representation by Ms. Stone that the motion that she did intend to elicit this particular piece of testimony. So I did not affirmatively address that issue in the hearing.
Well, I'll ask the attorneys, I guess, very briefly. Is there any legal distinction or anything that distinguishes the testimony of Ms. McIntosh from all of the other arguments made with regard to the questionnaire?
I would say yes, Your Honor, because the argument, as I understand it from defense counsel, is that this is the defendant's statement and it's based on her statements or her argument that it was compelled information on a document, which obviously the state disagrees with, but that the court, her argument is that the document itself and the information contained therein is compelled, but that same application doesn't apply from the phone number from which Mr. Quinn in fact calls, and Ms. McIntosh notes that observation. That's not compelled, that action is not compelled. And that's not information that he was compelled to provide to her. That's an action that she has observed. So it's wholly separate from the arguments that counsel has made. And those arguments would not apply to Ms. McIntosh's own observations and her interactions with Mr. Quinn.
Ms. Collette.
Pardon me, I didn't mean to stop. Clearly, probably I disagree with the state's representation that this is wholly separate. I do believe that Mr. Quinn was compelled to make those calls. And I think it's part and parcel of the overarching purpose of pretrial services and the reason under which that they came into contact with one another. This isn't some third-party civilian witness standing on the outside of this case saying, this person called me from this number. This is a member of the court staff whose obligation is to supervise individuals who are released either on bond or on personal recognizance for the court.
And pardon my interruption, Ms. McIntosh does not work for the court.
I'm sorry, I forgot that pretrial services is technically a separate entity, but reports to the court, if you will. I think that's a distinction that might have some meaning with regard to the court statement. Furthermore, I don't know what value that evidence has. It doesn't link Mr. Quinn in a meaningful way to the number. So, and let me give you a for instance. If I pick up the phone, I have caller ID on my desk, and I see a number on that, and I talk to another person on the other end, I can't say that they own that number. I can't say what another individual's interaction is with that number and that person. I can't speak to that. All I can say is that I saw this number on a caller ID when this person called me. I would suggest to the court that it lacks a level of probativeness that would not do anything other than make it unfairly prejudicial under 403. And it doesn't really reach the level of saying this belongs to this person. Again, I fall back on part of what I wrote in my motion, and that's the notion that there are other means by which the state could have obtained this information, and it just simply were not avenues that were sought.
Thank you. Well, the court is clarifying its ruling that it is including in its ruling granting the motion to suppress the testimony of Ms. McIntosh with regard to the phone number relating to the named defendant in the 442 case. I am granting that motion and that clarification specifically, without prejudice, not the motion to suppress. I'm granting that motion, and I don't expect to address it again. It's been fully briefed. But with regard to that clarification, if the parties wish to brief that again, brief that for the first time, you may. But having heard brief argument, I believe that it falls within the court's ruling on the motion to suppress. And for those reasons, the court is granting the motion to suppress. I believe that addresses all of Ms. McIntosh's testimony. So that's the court's ruling at this time. Again, if the parties wish to brief issues that have not been briefed yet with regard to Ms. McIntosh's testimony, not the pretrial release questionnaire, I would hear that later. It would have to be something different than what I've already heard. So, that was a specific motion to suppress. In 2 of these cases, there is a motion to suppress based upon the search warrants, and that applies to the Lee case 443, in which Mr. Smith represents the defendant, and it applies to the Matthew Tran case in which Ms. Segal represents the defendant. Have I summarized that correctly? So that issue, I think we can address briefly with argument because it has been fully briefed by the parties. Is that something we could address next?
The state is open to that, Your Honor, but to Mr. Smith, I think it's his motion.
It was prepared by Mr. Smith, and I joined it as well, at the court's direction that we not separately brief issues, and he certainly very carefully went through all the elements there. Judge, are you going to want to hear from other parties as to join the request that the ruling you made in Ms. Collada's motion apply to all other parties, or shall we assume that that will occur?
My apologies. I told you that I would give you the opportunity to be heard, and I didn't. I'm so sorry. Do you wish to be heard on anything with regard to Ms. Collada's motion?
Judge, I just wish to be heard in that. I don't know that it directly applies, but I assume the court will apply the ruling that was made in Ms. Collada's case as far as pretrial services and information obtained during the function of pretrial services by Ms. McIntosh not be used against Mr. Tran.
So I don't know whether there is any such information or whether there is such planned testimony by the state. I didn't see a motion in any other case, so my ruling is what it is from what I knew on the record. I don't anticipate any difference, but I don't know whether there might be differences in the cases. So,
and so I guess we're putting the state on notice. I am putting the state on notice and the court on notice that I would intend to rely on the similarities in that case if it arises, that the ruling that was made in Ms. Collada's case.
have you talked with Ms. Stone?
I have not talked with Ms. Stone about this. I'm not sure that it actually even does apply to Mr. Tran, but again, in an abundance of caution.
Well, let's just bring that up after you've had that conversation.
I will do that.
That would be great. So, Mr. Smith, do you want to address your motion? And again, I do anticipate brief argument because I think the parties are familiar with this record. I'm familiar with this record.
Very well, Matt. I will largely stand on my briefing. I would just like to make a few observations. This case, as the court can see, insofar as the search warrants are concerned, present 3 major topics. I analyze it by calling in the main factors. They're not the only factors I would consider to counsel. But the 3 main factors that I would like to point out are, 1, the power consumption, the fact that there was, with respect to the 63 Downey Lane residents, and outbuildings. There was increased power consumption. And of course, the court will portray that as a factor suggesting a grow operation. The second factor is the traffic, the number of visitors that would arrive at the various locations. They seem to consist of the same people. And there were 6 in number. There were 6 cars, including the truck. And as I described it in my brief, they were cross-visiting one another. Now, the next factor is the odor detection by Detective Packard. He had, with respect to the Downey address, he had detected the odor of fresh marijuana, which he opined was coming from the outbuildings. And that was specifically mentioned in the affidavit. My contention is, and I support case law, is that if you take the increased power consumption and the traffic and the associations, the cross visitations of these individuals, if you just take those 2 factors, that's not sufficient for probable cause. And I've provided in my brief the case law. I can just have the one before. Well, I know the power consumption, State versus Olson dealt with that. And with respect to the many frequent visits from like individuals, I've included U.S. versus Huguez Ibarra on page 4 of my brief, to the point that this type of visitation from others, even if they're great in number, is not sufficient for probable cause. Now, as far as the odor can be fatal to the defense, because it has been held that when a qualified person, an officer, for instance, recognizes or detects the smell of marijuana, whether it be burning marijuana or fresh hewn marijuana, that alone is sufficient to find probable cause. So I spent a little time addressing that fact, because if that prevails, then that's sufficient for probable cause. And what I am contending now is that in this particular case, the state's affiant, was Officer, the person that signed the affidavit, did not sufficiently lay a foundation as to the Detective Packard's expertise and experience in training, but instead just made a conclusory statement that he had experience and training in being able to do that. And I contend that that is not enough to be relied upon for the finding of probable cause. So with that out of the way, then I submit, Your Honor, there is nothing else there of any great import that would satisfy probable cause in this case. Now, the prosecution indicates in her brief that there was a humming sound as if it was coming from a fan. My criticism of that is the officer never saw a fan, but only said it was a humming sound. So it could be any number of things that was heard. So with that said, Your Honor, I'll answer questions if the court may have any.
I don't have any. Ms. Seago, do you wish to be heard at this time?
No, Judge, I would adopt Mr. Smith's argument.
Thank you. Ms. Stone?
Well, I think there's a number of issues associated with that argument. The first is that each of the arguments that counsel has provided on behalf of the search warrant is the fact that I would agree if it was a power alone, if it was a traffic pattern alone, if it was an odor of marijuana alone, that would be enough. But that's not what we have here. And what counsel is asking this court to do is to read these events or these pieces of evidence in isolation. And that's not what the case law is. The validity or the search warrant is presumed to be valid. Essentially, that's because all of this information has previously come before a court, and a court has evaluated it to determine if there's probable cause. Judge Schaller, I believe, was the judge in this case that reviewed that order or that probable cause warrant, and she's entitled to have deference, great deference, in fact, towards any reasonable inference. And it's any reasonable inference that any reasonable person could make, and it's not the certainty of finding evidence, it's whether there may be evidence in the place that's asked to be searched. And in this case, what you have instead is you have an odor, you have humming, you have the high power records, which notably from the case law, odor and power records alone would be sufficient. You also have the obfuscation of records that I believe I called it the shell game, essentially, and that's what's described. You have people living in a house, but they've got the power records for other houses, but they've got vehicles that are registered to them at other addresses, yet they're all seen moving around these same locations. You have the constant traffic flow, and not only the video surveillance, but you have the in-person surveillance that's identified by officers that are watching the same group going consistent behaviors with the maintenance, the care, the harvesting of marijuana. You have all of those things. You also have the lack, as the Department of Employment and Security shows, the complete lack of any reported income in the state of Washington, yet you have that homes have been owned for a year plus. You have that the significant amount of overhead required for all of these things, for which there is no paper trail, apparent paper trail, or reported income to the state of Washington to cover those things. You have the humming noise. And so, as counsel has described, he's identified to the court these things that maybe individually wouldn't be enough, but altogether they formed a greater picture, which is what the reviewing magistrate already took into account. It's not whether this court might have viewed it differently, it's whether this court can find that the preceding judicial magistrate's review of that was wholly unreasonable, and no reasonable person could have come to that same conclusion or made those same inferences. And it simply can't do so from the state's perspective on this record. Additionally, the argument from counsel that the odor of marijuana based on Mr. Bach's statement of training and experience is not enough. Well, as the state reads it, that's not his statement, that's the officer or Detective Packard's statement, which he says he was able to smell the odor of fresh growing marijuana, which he knew to be the same based on his training and experience. That is Agent or Detective Packard's description of how he recognizes it. And not that he recognizes it once, not that he recognizes it twice, that he recognizes it 3 separate times in 2 separate locations, that he recognizes it specifically as that smell, not as some other smell, that he recognizes it as that smell as fresh growing marijuana, in contrast to something else. That's how he describes it. And at the same time that he's smelling that, they're hearing the humming noise coming from the same place, which they again associate with those fans. The argument, well, we never saw a fan, so therefore they can't say it's a fan. Well, we already know that that's not the standard, because the standard when you smell fresh growing marijuana, even if you don't see it by definition, that's still giving credence in terms of how the court evaluates it. So would we have preferred additional facts? Sure, absolutely. More information is always better, but that's not the standard for finding whether or not a reasonable inference can be made. And it's certainly, especially when you're talking about marijuana in our current state laws, the state asserts that that is a reasonable inference for Judge Schaller to have made that Detective Packard in fact smelled exactly what he identified he smelled based on his job, based on his status, based on his assignment with the Thurston County Narcotics Task Force, based on what he heard at the same time, the number of times he smelled it, that he smelled that thing in multiple different locations and identified it specifically as that versus something else. And also, when we talk about the smell itself, you're talking about something distinctly more, and I briefed that in the initial part of Section B, talking about marijuana as something significantly more accessible now as well in our state, which is much different than State versus Olson, which occurred in 1994, where the state would assert that wasn't the case. So while the state would agree with Mr. Smith, if that were to stand alone, it wouldn't be enough. But in conjunction with all the other information that the reviewing magistrate had at the time, the defense has not carried its burden to find, for this court to find that the inferences and the conclusions that were made by the reviewing magistrate were unreasonable, and that that deference should be overturned in favor of denying or suppressing the evidence from the search warrant.
Thank you. Mr. Simpson, I noticed that you also had a motion, and I apologize that I didn't offer you the opportunity to address the court as well. I know that your motion was a little bit different than the motion of Mr. Smith and Ms. Segal, but do you mind addressing your argument at this time?
No, Your Honor, I can do that. Just make my way forward. And so, yes, in the case, separate case, 545-34, I did file the motion, and I do rely on the written briefing here. But I do want to highlight some additional things for the court. I think things that are going to be very important to consider. The basis of the motion is essentially that whereas law enforcement did provide a number of facts in their affidavit to the issuing judge, facts in support of a search warrant, everything that was contained in that affidavit describes legal behavior or legal facts. What we're looking at are movement of vehicles. We're looking at a person having a bank account. We're looking at persons maybe having a humming noise coming from their garage. It's not illegal to have a humming noise coming from your garage. It's not illegal to have high utility bills. All of these things are legal in the state of Washington. And so that collection of facts, that collection of assertions and even conclusions cannot get an issuing judge to the point of being able to say, well, a reasonable person could determine that there was criminal activity happening there. There needs to be something more. There needs to be an extra element. Because if there isn't that extra element, then everything described is lawful behavior. One other example, I pointed to a couple of examples in my brief that this type of warrant could be used, against any, type of marijuana operation in the state. That would not just include, the recreational pot industry, but also the medical marijuana industry, or the regulations that apply to medical marijuana in the state of Washington. Cooperatives, in particular. So I know that the state has raised it in their brief, that it could be a reasonable inference that it was unlawful manufacture of a controlled substance because the rules for recreational marijuana would not allow somebody to do it in a residential area. Well, the rules for any cooperatives are completely different. They would allow somebody to set up a cooperative in a residential area. So again, if you look at that, and I'm citing to RCW 6951A 250, the reasonable inference is simply not there. It is still the only reasonable inference that could be made from the lawful facts that the deputy put forward is that there was legal activity going on, or that there wasn't necessarily anything illegal. Turning to just a few issues, this is a sort of a fact-heavy argument, but a few issues that were raised in the response to the brief, and I'm referring just the areas where the state goes into some of the more factual issues here, that the Liquor Cannabis Board will not approve a marijuana license for a location where law enforcement access without notice or cause is limited. That refers to the recreational area. But even if you think about that aspect, law enforcement didn't put any of that information in their affidavit either. They didn't describe to the issuing judge that, well, this house is in a residential neighborhood, Your Honor, so it obviously cannot be something where there was recreational manufacture of equipment. It's tied in with the cooperatives issue where you have to rule that aspect out. So law enforcement didn't include any of that information. The state is relying on individuals applying for marijuana license must have resided in Washington State for at least 6 months prior to applying for a marijuana license. Again, I don't see anything in the rules for a cooperative that would be the same. Again, citing to RCW 6951A 250. The other issues that the state says to enforcement can access a licensed marijuana business without notice or cause. That is part of the recreational scheme in Washington. That doesn't apply to cooperatives either. A cooperative can be in a residence. A cooperative can have all of the similar characteristics as to what they described as criminal activity here. The simple fact is that the affidavits describe everything that's legal, and they don't give sufficient information to the issuing judge to be able to determine that criminal activity was occurring. Going on, another fact to support the reasonable inference I'm quoting from the state here is that they checked employment records. That is, I hesitate to say misleading, but it really doesn't say anything in the sense that it doesn't talk about anybody possibly being a sole proprietor, having retirement income, having an annuity, having investment income. The fact that somebody, doesn't have employment records would simply mean perhaps they haven't worked for somebody else. It doesn't necessarily mean that they're engaged in criminal activity if they don't have employment security department records. The proper place to go, and where law enforcement didn't go, was to the Department of Revenue. If you want to see if somebody's paying taxes on a business, you go to the Department of Revenue. If they didn't do that in this case, that would be necessary information for the court, or for the issuing judge to have.
Can you sum up, please?
In addition, or the bottom line here is I think that they would need to check with the Washington State Liquor Cannabis Control Board. They would need to double check before asking a judge to issue a warrant. They would need to make sure that there wasn't a lawful license in place first. They would need to make sure that there wasn't a registration for a cooperative first. Otherwise, they're stepping forward ahead of the Fourth Amendment. They're subjecting possibly people protected by the Fourth Amendment to unreasonable searches.
Thank you. Mr. Smith, do you have anything else after having heard from the state?
Yes, I would just like to make a brief comment. If the court, if I may, the court will look at page 7 of the affidavit for the search warrant. And go down to line 13, that paragraph starting with line 13. It says, and I'm reading this, while doing this, Detective Chris Packard was able to smell the odor of fresh growing marijuana, comma, which he knew to be the same based on his training and experience. So there are 2 points here. Number 1, that Detective Chris Packard smelled marijuana. But number 2, that phrase, which he knew to be the same based on his training and experience, has an ambiguity there. It doesn't tell us clearly that the fact that he knew to be the same, the fact that he had training and experience in that regard, whether that is the source of that statement, whether it was Packard that was the source of the statement, or whether it was Officer Bach who was the source of that statement. Had the, as I indicated in my brief, had the detective's training and experience been laid out, then that would eliminate that problem that I'm speaking of, that ambiguity, because detailed information that carries with it a ring of reliability. But here, all we have is a conclusion that Detective Packard knew the odor of marijuana, but we don't know if that was his statement or whether it was Officer Bach's statement, who was just drawing a conclusion on his own. I'd just like to point that out. Thank you.
Thank you very much. I appreciate that the attorneys likely have more to say, but I believe that the briefing was quite thorough. I allowed the attorneys to provide argument. The law is quite clear on the standard when the court reviews a search warrant. There are different issues on each of these 3 cases. And so in the brief that was filed by Mr. Smith, he is challenging the search warrant of the 63 Downey Lane address, the person, Mr. Lee, and Lee's car. In the other cases, the challenge is to the individual defendants as well as the address. So these arguments do apply to all of these motions, even though they're in reference to different people, and perhaps they're the address associated with them and or the car associated with them. As to each of them, the parties recognize that there is deference to the judge who issued the search warrant after reviewing the affidavit, which was lengthy. And although I believe each of these arguments by the defendants has some merit, they take out of context all of the facts presented in the affidavit. Power consumption was part of it, traffic was part of it, odor detection was part of it. There were also additional facts with regard to the address itself, the humming, other things associated with the address and the individual vehicles. Some may not have very much weight. Some may not lead a reasonable judicial officer to conclude that there was probable cause. But when considering all of these facts as a whole in the lengthy affidavit, the court finds that the search warrant was supported by probable cause when the court considers reasonable inferences as to all of the facts presented in the affidavit. If the search warrant were supported by an affidavit that only contained 1 or 2 of these facts, we might be in a different situation. But considering all of them as a whole, the court finds that there is probable cause. And I will say that I appreciate that many of the facts in the affidavit do support lawful activity. And that is not unusual in an affidavit, that some of the facts are or support completely lawful activity. But it's putting those pieces together, and the court must determine whether putting those pieces together does support probable cause. Again, not proving the state's case, just supporting probable cause that criminal activity was occurring. Now, it might also support other activities. There may be many hypotheticals, but the court finds that on this record, the search warrant was supported by probable cause as indicated by the facts in the affidavit. Do the parties require any further clarification with regard to that ruling?
No, Your Honor, thank you.
No, Your Honor.
No, no.
No, Your Honor.
And so I believe we still have the defendant's motions in limine. I am going to have a brief break, which I should have taken before. And I forgot about another element that I should have brought up at the very beginning that was not scheduled to be addressed at this hearing. And perhaps the parties have a different plan. But I noted when I reviewed the files in this case that the state has filed amended informations. And at some point, we need to do arraignments on those amended informations. And I apologize, I should have put that at the top of the list at the beginning of the hearing. I did not. But again, like I said, we need to have just a brief break, which I should have called before. What I'd like the attorneys to do during this break is to address, to discuss the potential motions in limine. I've sort of made a chart of all of those motions. It appears that many of them are agreed. As to some of them, the state appeared to be confused as to what was being addressed. And so, Ms. Collada, with regard to your motion that was fairly extensive in terms of various issues raised, the state appeared to be unclear about number 10, number 13, number 14, and some of those same issues were brought up by other defense counsel. 404B, the state appeared to be unclear as to what was intended by the motion. What I'm hoping is that during this break, the attorneys might be able to come to some clarity and say, you know, there aren't any 404B issues, we're all in agreement, we're okay, so that hopefully in the time we have remaining today, we can address only those contested issues. And if we need to do arraignment, we'll do that when we get right back on the record after a 15-minute break.
Thank you.
So first of all, do we need to address arraignment?
Yes, Your Honor, yes. I think the only one who doesn't have an arraignment actually is Ms. Collada's client. Everybody else has one. They've previously been filed, they've previously been sent. They also had hard copies today that I again provided to counsel so that they would have this before.
And I see all defense counsel is here. Are all of the defendants in the courtroom?
My client's here.
My client's here.
My client is here.
Okay. So I don't know if the defendants wish to come to the lectern for arraignment or not. It's their choice.
Well, Judge, I probably told Mr. Tran, Mr. Tran, you wish to come forward.
No, it has nothing to do with me, so.
So Mr. Tran doesn't wish to come forward.
Judge, I would just reiterate this has nothing to do with me, is what Mr. Tran has indicated, is patently, factually inaccurate and concerns me as to his understanding of the process as well as the conversation I just had with him, where he does not believe if he were found guilty of the charges currently filed as well as the one that is about to be arraigned, that he could or would be taken into custody that would happen. He does, based on the information he's received, obviously not from myself, he does not believe that that could occur. I'm making the court aware of that. At this time, if the court can allow Mr. Tran to sit in the audience for arraignment for the First Amendment information, I would ask actually for a formal reading of it's short, I think it's relevant, and I think it assists me in trying to make sure everything is clear and on the record that Mr. Tran, while not at the lectern, is in the courtroom and has heard what the amendment is. I have shown him the document as well.
I appreciate that. Mr. Tran, please come forward.
I would like to say something on the record.
I'll let you state something on the record after we proceeded with arraignment. Please come forward.
No, I need to say something on the record before we continue.
Please come forward.
I can't do that.
Can you call security, please?
I'm cooperating.
We need to proceed with arraignment. In order to do that, you need to come forward to the lectern, and I'll let you say something.
Why do
Please
I
don't interrupt me.
I'm sorry, go ahead, yes.
In order to proceed with arraignment, you need to come forward to the lectern. And I'll let you say something on the record after we're done, but we have a lot to get through in a very limited amount of time. So please come forward. I'll call your matter in just a moment. We'll go forward with arraignment on the David Lee case, cause number 18-1-443-34. Mr. Lee? Mr. Lee present?
For the record, he is present, Your Honor.
Mr. Lee, please come forward to the lectern. Well,
I should clarify then that I know that Mr. Lee is in the courtroom.
okay, your client is in the courtroom, but he's refusing to come forward?
Will you step forward, Mr. Lee?
Who are you talking to?
He asked, who am I talking to?
So I guess we're not going to proceed with arraignment today. So I am concerned that these kinds of activities are not going to be able to continue when we have trial. And I know the attorneys know that, but we're going to have some more cooperation. I'm hopeful that the attorneys can talk about a better plan. I'm just trying to move this forward. Perhaps what I'm doing doesn't work for these defendants, so I'll wait for a better suggestion, but we're going to go forward with the motions in limine today. We'll have to do arraignment perhaps tomorrow or at a different time. So, on the motions in limine, I know that all of the defendants are in the courtroom. They're not at the lectern, but their attorneys are all present. There are two motions in limine that we still need to address. And those are the motions in limine filed by Ms. Collada in the 442 case, and the motions filed by Mr. Swady in the 444 case. I'm assuming that there's some agreement among the defendants that they agree that these motions should be made on behalf of their clients as well. So I say that because I'm not presuming that Ms. Collada made the motion and Ms. Seeger does or does not agree. I assume it's that there may be agreement on behalf of others. So my understanding from the briefs is that with regard to Ms. Collada's motions, number 1, number 2, number 11, number 12, number 15, and number 16 are agreed.
I think we have additional agreements, Your Honor,
Okay.
for the court's purposes.
Before I hear that, is everybody in agreement that those that I've listed are agreed?
Yes, Your Honor.
You're asking for the defense counsel if we are agreeing as well.
Yes.
On behalf of my client, we're agreeing.
Is there any disagreement?
No disagreement from Mr. Tran's defense counsel.
No disagreement.
No disagreement. I can clarify what we talked about with regard.
That's okay, we're not there yet. So, those ones that I've just mentioned are agreed. And Ms. Stone, you said there's agreement on other motions brought by Ms. Collada.
Yes, Your Honor. So I think as Ms. Collada and I spoke, number 3, what we understand to be, well, I will back that up. Let me go straight to the ones that are agreed versus understood to be reserved. The other agreed was 13 and 10 and 14.
That is accurate.
Is 14 agreed in that there is no 404B evidence?
Correct.
Okay.
Correct, Your Honor.
Ms. Stone, is that true for all of the defendants?
I believe that's true for all of the defendants. There's nothing as the state went through that it could identify as 404B evidence. And I tried to address that in my response too, so I hopefully that clarified, which I think it does. So there were a couple for number 3, Ms. Claude and I spoke about, and that, as I understand it, is reserved. So she's not asking to move forward with that today. It would be based on fact-specific time it came up. Same with number 4, we asked to reserve. And not to speak for Ms. Claude, it just,
And perhaps it's easier if I go through them
Sure.
to make the record. And Your Honor, specifically to go back to number 3, the reason being is that is an objection to evidence without speaking to the specific piece of evidence, and so that's why I'm agreeing to reserve that. With regard to number 4 in my motions and limine, the reason why I have agreed to reserve that is on the basis that Ms. Stone believes she can lay a foundation. I will re-raise that objection at the time if I think that foundation is insufficient. I believe the same goes for number 5 with regard.
With regard to number 4, I know that we already addressed the issue of pretrial release questionnaire. Is the remaining issue the birth date issue?
No, the remaining issue is that there's only a cell phone, a Cellbrite data dump of 2 of the co-defendants' phones with a number that has the name Michael listed next to it as being my client's number. That's the only relation to that phone number. There's no direct evidence that belongs specifically to my client.
Now, I understand that's your argument.
Correct.
My question is the evidence that you're asking to be excluded.
Yes, and so I'm actually asking for the identification of that phone number belonging to my client by police officers to be excluded as unfairly prejudicial on the basis that that testimony based on discovery I have is them making conclusions and assumptions of the hearsay evidence available in the cell phone data.
Okay.
Is that sufficient?
Right, I'm trying to distinguish number 4 from number 5.
Oh, absolutely, and pardon me, let me, if I may, respond to that. Number 5 is specifically with, so let's say the number is identified and the court lets it in that it's my client's, and there's the text message, the content of the text message. I would suggest to the court, and this one could potentially be reserved too, depending on the specific message, that an officer on the stand does not have personal knowledge in a manner that would allow them to interpret what that message says.
Understood. I understand number 5. I was less clear on what was left with number 4.
Okay.
So I think we're clear now.
Okay.
So if you could continue with your list.
With regard to number 6, I do believe based on the stills I've been received that I can withdraw that particular motion in limine at this time. Number 7, I would reserve the argument on that, based on an agreement with Ms. Stone and the state that should they seek to specifically identify my client in any of the video surveillance stills, they will alert me so that I may object if I do have an objection at that time. With regard to number 8, that is reserved too. Ms. Stone believes that she can lay the proper foundation so that certain officers may testify to certain subject areas. And one that is outstanding, and I would seek the court's ruling on, is number 9. And I do believe that potentially.
Should just leave 17.
I was just saying 17. And with regard to motion 117, I just stand on the records independent.
Okay, so, we need to have arguments still on number 4 and number 9. Is that correct?
I don't know that I'm further able to make on number 4, unless the court has specific questions.
Oh, I'm sorry. 4 is reserved, you said?
Yes,
By
please.
agreement. Number 5, does that remain contested?
I believe it has to be raised at the time each individual text message is elicited.
Okay, so you're reserving that one as well.
Yes, please, Your Honor.
Okay, so number 9 is the only one that needs to be argued.
Yes, please.
Okay, so to summarize, by agreement, number 1 would be granted, number 2 would be granted, number 3 would be reserved, number 4 would be reserved, number 5 would be reserved, number 6 is withdrawn, number 7 is reserved, number 9 still needs to be argued to the court, number 10 is agreed, number 11 is agreed, number 12 is agreed, number 13 is agreed, number 14 is agreed, number 15 is agreed, and number 16 is agreed, and with regard to number 17, it's not agreed, but the parties will rest on their agreement.
Correct, Your Honor.
Okay. Is that summary accurate for the remaining defense attorneys?
No, no objection.
I believe that's accurate.
No objection.
Okay.
Okay. So with regard to 17, Mr. Swaby, you made a motion on this same issue as well. Do you wish to be heard any further before the court rules on?
No, Your Honor.
So the court's ruling is as follows. The court does not expect any testimony in this case that references any person as a victim. I don't believe that that's appropriate in this particular case. I don't generally allow it in any case, but in this case in particular, especially with the state's response, the court does not expect anyone to be referenced as a victim. With regard to the term defendant, the court appreciates the argument of defense counsel with regard to that term. However, it would frankly be impossible for the court itself to comply with an order limiting the references to the defendants as the pattern jury instructions refer to the defendant. At the opening of the case, the court will refer to the parties, including the state being the plaintiff, the defendants being the defendants. And so I don't think that it makes any sense for the court to not allow the parties to reference plaintiffs and defendants, and specifically the defendants in this case. It just doesn't make sense to exclude that term. With regard to the term suspect, I am not aware of a specific instance where that will be appropriate for this case, but I will say this, it is not my expectation, if there are documents in this case that refer to suspects or a suspect, that that document would be redacted. I would encourage all witnesses to not use the term suspect, but I'm not going to order that no witnesses may use that term. Another reason that my ruling is the way that it is because I've learned from experience that when granting motions in limine, it's important that they be enforceable and enforced and consistent with the practices of this court. I have in the past granted an agreed motion to not use the term suspect, and then the parties routinely among themselves use that term. I don't expect that here. I am not familiar with documents that might be used in this case that have that term in it. So to the extent that we could avoid it, I would appreciate it. But I'm not requiring it at this time. If that becomes an issue in this trial, in other words, if any witness is using those terms in a derogatory manner, rather than the way that the court will use it, which is simply a factual matter, I will readdress it. Do the parties require any clarification of the court's ruling with regard to number 17?
No, Your Honor, and I would add to it, only in that sometimes when you ask people not to say a term, then it becomes to the forefront and they inadvertently continue to say it, whereas they may not have otherwise. So I appreciate the ruling, and if it becomes an issue, I would just ask counsel to let me know, and I will readdress it with witnesses.
I understand.
And that brings up a different issue with regard to tone. I know that sometimes, words are spoken that are perfectly permissible, but the tone is evident in the courtroom. I expect that all of the attorneys would properly advise their clients and their witnesses with regard to tone in the courtroom. I hope that that's not an issue, but if it's an issue for anyone in the courtroom, please bring that to my attention so that I can address it as early as possible.
Understood, thank you.
Okay, so we know we have one contested issue with regard to Ms. Collada's motions. With regard to Mr. Swaby's motions, it appears that because of the overlap, there's perhaps agreement. Oh, did we address number 1, the exclusion of witnesses? It was agreed.
Yes.
So let me say something about that. Is it the state's intention to have one witness at counsel table?
Yes, Your Honor, that would be the assisting officer.
And is it the state's intention to have that assisting officer in the courtroom from the beginning of trial to the end of trial?
It is, Your Honor, yes.
Okay. So, Mr. Swaby, are you in agreement with that?
Am I in agreement that they are allowed to have that person sit there throughout the trial? I think the case law says that they get to have someone sitting with them. My concern, as addressed in the motion in Limine, is how we go about their testimony. My concern is that that witness, listening to all of the witnesses testifying before him or her, is then allowed to shape his testimony to fill in holes, perceived holes, Your Honor, in the testimony that a witness would not normally be allowed to do. Counsel for the state, Ms. Zoe, responded to the motion, and we have talked about this. They don't intend for that witness their plan about testimony is not to have that witness testify several times during the trial, although they may have to break up, is that fairly said? They may have to break up the testimony for reasons that appear to be appropriate. I'm concerned about the officer, as I would be about any other witnesses hearing testimony. I'd like to think that between the five of us, there'll be effective cross-examination, and that witness may try to fill in holes for other witnesses we successfully impeach.
So with regard to the motion to exclude witnesses, are you in agreement?
I am in agreement with, yes.
I understand
Yes.
you may have different objections because of that.
Yes, I'm sorry, Your Honor. I'm really trying to listen to you and answer the question you're asking, and I know it doesn't appear to be the case, but I really am. I don't have any objection to that their witness get to sit with them throughout the trial. I ask that everybody else be excluded from the court.
Understood, and I think that's agreed by all, so that one is agreed and granted. It's been a long afternoon, so we just need to be accommodating of each other. I appreciate that. In addition, Mr. Swaby's motions, C, I, and J are agreed, as far as I could see, by the state. Are there other agreements?
Yes, Your Honor.
Yes, Your Honor, I can let the court know that Mr. Swaby's motion D, the prior bad acts under 404B, that's been agreed. His G, general right to impeach, and also H, motions to prohibit argument. Mr. Swaby and I talked, and we are in agreement. The only thing I will indicate is that we are in agreement, but taking into account the state's response and our response to his motions in limine.
And that makes sense to me.
And it did to me as well.
And then I can let the court know, I believe the only two remaining matters are B, motion to exclude hearsay by police officers, and E, motion to reference any of the defendant's hearsay statements or potential witnesses. Those are being reserved at this time. My understanding that Mr. Swaby just cited to the court what the law is, and I think when these issues, if these issues come up during trial, they will be addressed at that time.
What she said.
Okay, excellent. And I think that's true with some of the state's motions in limine too. I appreciate that the parties have filed these motions in limine to bring to the court's attention and to each other's attention evidentiary issues that might come up. And I very much appreciate that. It's helpful for the court to be aware that these issues might come up and be prepared to address them during the course of trial. I trust that the attorneys will bring these up at the appropriate time if they become an issue, and we'll address them.
Thank you.
So, I think that that leaves us with the last issue to be argued, which is number 9 of Ms. Kalata's motions. And is that the last issue we need to address today?
Should I have an individual matter I need to address before we?
If I may, counsel, could it be all right?
By all means, please help yourself.
As the court knows, on behalf of the defendant named Ken Liu, I filed a motion to dismiss. Counsel for the state has filed a response. Your Honor, I'm satisfied if the court rules on that on the paper without argument. When we talked about scheduling, I forgot, I scheduled this tomorrow, and I am due in both Yakima and Kennewick tomorrow. I've sent out messages to those prosecutors trying to move those dates to Friday because, as far as I'm concerned, I'm in trial. But in thinking about the motion, I have made, or my client has, the registered agent for my client has made those arguments before this court before. I wanted to reduce them to a writing. I am satisfied that this court understands the purpose of having filed the writing and could address the motion without the need for a
Is your client satisfied of that as well?
The registered agent for my client is going to want to, he will, I expect, be addressing these arguments on behalf of the person for whom he is a registered agent during the trial via testimony himself. So the need to address it tomorrow, I believe, is unnecessary. Yes.
My apologies for the confusion. Are you referencing your client as the registered agent of your client?
The person who has stood next to me on some occasions during the course of these hearings maintains that he is the registered agent for the person named in the information called Ken Liu. It is an argument I believe each one of them has made at one point or another. My client is steadfast in that position.
You've been appointed to represent an individual.
Yes, Your Honor.
is that person who I'm calling your client, that individual, in agreement that your motion to dismiss scheduled for tomorrow should be addressed without oral argument?
I'd have to inquire, Maybe you could address Ms. Collada's issue one way.
Ms. Segal?
Judge, I guess it doesn't matter where we're something done at this point. I just wanted to reiterate to the court that I did answer ready with a caveat that I was going to be unavailable from May 1st to May 9th. I will be out of state. I do have plane tickets. I'm moving my 80-year-old mother out here from her home. That is when her movers are scheduled, and I have to be there at that time. There's no way for me to not do that. I also need to be, I think it's April 19th. I understand normally we would be going Monday through Thursday. The court had addressed the need if things ran over that we might have to go into a Friday. I cannot be here April 19th as I'm moving my house to a new household on April 20th. I need that one day.
And that's all in the trial confirmation order?
It should all be in the trial confirmation. I'm not sure if the April 19th was in there, Judge, but I could file something additional. But I want to make the court aware today because
Yes.
this is the first opportunity I had.
So, well, we've addressed that actually at trial confirmation, and I will say this again, with all of the attorneys present and all of the defendants present, I will be asking perhaps daily for the attorneys to provide a schedule for all witnesses and all testimony and any argument that will be completed by the time Ms. Segal has her unavailability. I know that there are other scheduling issues. I think Mr. Swaby said he had some dates that he was unavailable. We'll have to schedule around. The court may have some unavailability. I don't know that right now. I mean, there might be a half hour or something that I am unavailable. These are all things we will have to work around in the course of a long trial. And when I say that, I mean we will have to work around it. That means that we'll have to probably have witnesses waiting in the hallway. We're not going to run out of witnesses. We're going to go till 5 every day. If it's not looking like things are going well in terms of our timing, we'll start early. We'll have shorter lunches. We'll do whatever it is that we need to do to get this trial completed within the time that it's scheduled.
And then may I speak up? Does the court anticipate having trial take place on Fridays? I thought I heard at a previous hearing that that's not anticipated.
That is not anticipated.
No trials. I'm sorry,
ma'am. I was saying the 19th, about which Ms. Segal was concerned, I believe, it's a Friday.
It is Friday.
It is a Friday. I don't anticipate that, but I also don't anticipate starting at 8 o'clock, but we may be starting at 8 o'clock as well.
Okay, it's a possibility, but you don't anticipate, as I understand what the court just indicated.
I'm saying it's a possibility, but as you know, the court has other matters. It hears all days on Fridays, and they are scheduled. So if I were to have to make myself available and this courtroom available on a Friday, it would be a very significant disruption, not to myself, but to many, many other litigants who have plans to have their matters heard. So that is not my plan, but I say that because I cannot be more clear that this trial will complete by the end of April. And so we may need to be creative in our scheduling. I hope not. It is my hope, and I said this at trial confirmation, I think that this case will take 8 days to try, and we'll be through it and we'll be completed. And I will do everything I can to try to have it done as efficiently as possible. But I don't control everything. Each of the attorneys doesn't control everything. And we need to make sure that we get this trial completed during the time that it's scheduled.
Thank you, Your Honor. I've been very clear on that, or clear trial confirmation, and I just wanted to just reiterate, in the interest of making sure everybody knew at least what my limitations were, and I will certainly be here for all the hours that you require me to be here.
So I don't think it's really possible to get a schedule of witness testimony and how we're going to be completed on time until after jury selection. So I say I'm going to ask for that every day, but day one really doesn't make much sense, does it?
And Your Honor, I'll tell you, the council and I work together routinely in front of the court as well with lengthy trials. We do schedule out our witnesses well in advance, in part just because the witnesses need to know when to expect to be present. And generally speaking, at the end of each day, that schedule gets revamped based on what's happened and where we're actually at in the lineup. So as a general rule, we come in knowing who we have on the schedule for today and our hopes for when that person is getting on the witness stand. Part of the process, I think, we'll just be waiting to see. I don't know what the cross-examination is going to look like. It could be short, it could be lengthy. So we're doing our best guessing, but we'll have that day before the court.
Appreciate it. So Mr. Swady, I'll turn back to you with regard to the motion scheduled for tomorrow.
So, it's not his case, so the decision is up. The response, we can go forward without argument.
Okay, your client is in agreement that we can go forward without argument tomorrow.
My client is in agreement that this is not his case, so it's not his say.
That doesn't make any sense to me.
It doesn't? I'm really trying to advance that person's, I'm trying to reflect honestly with the court what is being told to me. Ultimately, the decision about how to go forward in this context has been left to me. I am satisfied that the court would give us a fair ruling based on the tape.
Very well.
Thank you.
The court has not reviewed the response of the state to that motion, which I understand was filed today, but I was doing other matters. So I am not prepared to issue a ruling. I will issue that ruling tomorrow. I think that everything has been filed with regard to that motion.
That's correct, Your Honor. The state does not
Yes, Your
have
Honor.
additional.
Excellent.
Well, I apologize, Your Honor. Before arguments on Ms. Collada and Ms. Stone's matter, I just want to indicate to the court, Mr. Simpson also filed motions in limine. The state has responded, we've also talked, and we've reached an agreement on all of them.
Okay, let me look at that. Yes, I saw that. The state did respond, and I'm sorry. I do have a chart that I'm looking at for all of these. And it did appear that there was some overlap, and that there was some agreement based upon the state's responses. So are you indicating, Mr. Simpson, I'll refer to you, it's your motion, that there's been agreement on all of the motions at this time?
Yes, Your Honor.
And so do you wish to put those on the record?
Your Honor, I have filed those numbers of 1 through 7, and I did receive the state's response to all of those, and did have an opportunity to speak with counsel for the state about those, and I was able to clarify some things about their approach, what their approach is to be expected at trial, and so we've come to an agreement.
So all of them are now agreed?
Yes, Your Honor.
So similar to the issues that I addressed in Ms. Collada's motion and Mr. Swaby's motion, can you put on the record as to whether they are agreed in terms of granting your motions, or agreed as to reserving those, or some other agreement?
Your Honor, with regard to, I can certainly go through each one of them, but some of them are duplicative. The motion to exclude witnesses, I believe the court's already granted that one. The motion to admonish witnesses not to testify to the ultimate issue. We're in agreement on that one as well, that the state's witnesses would not testify to legal conclusions or discuss their testimony with each other. that sort of dovetails with the discussion that was had about the state's wanting to have a representative sitting at council table and whether or not that person would be bringing or somehow.
Sorry to rush, but on to number 3.
Okay. With regard to number 3, the state indicated in their response that there was no objection, so that is agreed. With regard to 404B evidence, we have come to an agreement, my understanding is that there's not going to be any 404B evidence with perhaps the exception that I've already conceded, evidence of other crimes, anything to prove motive, opportunity, intent, preparation, time, knowledge, identity, or absence of mistake.
I'm sorry, opportunity, intent, preparation, plan, knowledge.
Or absence of mistake or accident. With regard to number 5, custodial statements, the state's response is they have no objection, that is agreed. The motion to exclude physical evidence that I brought, that was with regard to, specifically with regard to the firearms that were involved in discussing this with the state. They indicated that there is in discovery a lab report essentially that would cover how and why, or excuse me, not why, how the weapons were tested. And so upon further reflection, the necessity of having you go to the sheriff's office to observe them, I would withdraw that motion. And so me withdrawing the motion is our agreement there. Motion to exclude character or reputation evidence, the state indicated no objection, so we're agreed there.
Thank you. So we are getting down to the wire. We will have to be done by 5 o'clock. We still have one more issue to address. And it appears that after we address that motion, we do not have any more hearings scheduled until we begin trial Monday morning. So I want to take the time now, even though I know I have this argument left, to address some issues. There was some talk about a special questionnaire. I didn't see one, so I presume now that the parties will not be proposing a special juror questionnaire. I will be speaking with our jury administrator as to the number of folks who will be called in for this jury pool for this case. It will be a high number. If counsel has any input to the court with regard to the number of jurors to be called, that should be filed in the court file within the next couple of days. Obviously, that decision, that final decision needs to be made by Friday. So if you have any input to the court, you can file it in the court file by no later than Thursday. I'm not requiring it because that's the court's decision. It's not something I normally get input from the parties about, but if you wish to, you may. The court also has the usual deadlines for jury instructions. I don't anticipate any pretrial motions to be addressed on the morning of trial. We've addressed all of them already, except for the one that's outstanding. So I assume the parties will be ready to go at 8:30, and we'll plan to begin jury selection at 9 o'clock. No matter what, we're not going to begin before 9. We start with 8:30 just to go through any pretrial issues and that sort of thing. Ms. Stone?
The only thing we would still have as an outstanding would be the arraignment issue.
Indeed. And I think that we'll start that on Monday morning. I also very much appreciate any suggestions or a plan that the attorneys may agree to with regard to courtroom layout and where people will be seated and that sort of thing. As I said, we'll begin in courtroom 102 Monday morning. Eventually, we will be moved to another courtroom, likely this courtroom. We will be selecting 12 jurors and at least 2 alternate jurors. Again, if you have any input as to the number of alternates, you may provide that and file it in the court file. I'm not expecting briefing back and forth. I just want to provide a way for the parties to provide input to the court that they might not normally do. And that would be formally in the court file only. Please no emails to JAs or our jury administrator. So, anything else that I need to address? Mr. Sweeney.
Could I ask at this moment, Your Honor, what you're thinking of in terms of peremptories? That would inform some of my thoughts about the number of jurors and how we go about. So how might we divide those up?
Frankly, I've done it a couple of ways, but I think in criminal cases, obviously the defense has their typical amount of peremptories. We know how it works for the challenges for alternates. So I'm not exactly sure what it is that you're asking.
Well, Your Honor, when we tried the murder case this summer, the court split up. Oh, excuse me. I'm concerned that I'm not on the record, though we have a court reporter. Whose abilities are great, I know you're getting. We split up the peremptories in such a way that I recall the state didn't get as many as we got. I'm looking back to Ms. Zoe because I don't remember exactly how it was split up.
So I'm going to stop you there.
Yes.
If you have input regarding any of that, please submit it.
Oh, very well, Your Honor. Thank you.
As a logistical question, Your Honor, because I anticipate the parties are going to talk about all of these kinds of things in advance, and hopefully we'll be able to give a relatively agreed representation to the court. But once we move from 102 back up here, logistically speaking, with chairs and defendants and tables and equipment for the state to put on its case, will we have the availability to talk to court staff about maybe getting an additional table or?
Please don't talk to court staff about anything.
Okay.
If you need something, please ask me.
Okay, so if we have, logistically speaking, will we have the ability then to ask the court for more things to make space for more people? Okay.
Indeed, you may.
Do you want that filed as well?
Well, I think we'll probably talk about that informally, because, again, I am not the one that makes the decision about where our trial will be. Maybe here, maybe a different courtroom, and each courtroom's a little bit different. So I think we'll be able to just talk about that on the record.
Okay.
If that's okay.
Yes, Your Honor. Thank you.
Of course it's okay, Your Honor. I just want to make sure, you said something should be filed and something, I'm trying to get in more trouble than I'm already.
No. I want to be clear, though. When we're in trial, we'll be seeing each other a lot, and we'll have the opportunity to talk all the time. My concern and why I mentioned about filing something if you want to give input is because after 5 o'clock today, I'm not going to see you all again until Monday morning at 8:30. So that's why I'm providing you the opportunity to file things in the court file. That's really the only way I'm going to see anything from you between now and Monday morning. After that, I think we'll be seeing each other a lot.
Yes, Your Honor. Thank you.
Your Honor, I have just one other issue that I think needs to be addressed before everyone leaves today, and I'm referring to all the defendants. I don't think any of these individuals are familiar with how a trial works, and I see an immediate concern of starting out of having all the individuals stand up and introduce themselves. I would just ask that the court make the individuals, the defendants, all the defendants aware that there will be certain directions by the court that they will need to stand up and cooperate. I fear a mistrial before we get started if we don't have some direction to defendants' cooperation and some indication that they're aware that that's what is expected by the court.
I don't anticipate requiring the defendants to identify themselves to the jury. What I typically say in a trial is, defense counsel, you may introduce yourself and your client, and I use the word may. So that's my position regarding that. I think there may be a lot of other issues. And again, I'm hoping that the attorneys can come up with a plan. But I'm hopeful that I will not need to enforce that plan because it will be by agreement. The voluntary decisions of defendants in cases sometimes are not in their best interest in front of a jury, but those are their voluntary decisions. So I don't know if I can give very much direction right now. Certainly, all of us know what usually happens in a trial. I don't know if this is going to be an unusual one.
I appreciate it, Your Honor, that's what came to my head, and I wanted to address it now.
Appreciate that. Ms. Stone.
I think the only additional logistic issue, because of the size of our courthouse and the volume of jurors that we're going to have, and the nature of the defendants essentially traveling together and standing outside the courtroom together and speaking to that individual, specifically Mr. Ritzman, who is the one giving them regularly that advice, having those conversations out anywhere where a juror, potential juror, could hear it, is inherently problematic. And so that would start, I would say, even before we begin the trial Monday morning. That could be problematic in terms of the volume of jurors here in the parking lot and out and around. So that's one of the state's concerns, just in terms of congregation.
Let me be clear then about all of the motions in limine. The agreed motions in limine are orders of this court. I expect, as I do in every case, the attorneys to advise their clients that they are required to abide by the orders of this court. That includes that they may have no contact whatsoever with potential jurors or jurors after they are seated. And that may require some logistical changes in the way we move people around. For instance, during a trial, and I've done this before, even in defendants who are out of custody, would not be able to have their breaks out in common areas. They'll need to go somewhere else in order to not have that contact with potential jurors. And again, the space here at this courthouse is not helpful. We are limited in the common space, but we'll have to think of a way to ensure that this court's order will be followed. There will be no contact between potential jurors and the defendants. That is not allowed in any way, shape, or form. No matter what that contact is, I tell people all the time, even a hello or a handshake is not allowed. I'm sure that the attorneys in this courtroom are aware that I've had the opportunity to have to address an issue of a witness having inadvertent contact with a potential juror, and that is not acceptable to this court. To the extent that this court needs to make some sort of arrangements, please bring that to my attention. There will be no contact with potential jurors between the lawyers, their clients, the defendants, any witnesses. No contact is allowed. So I can't be any more clear.
Thank you, Anna.
So we're down to 8 minutes. I'll give you 3 minutes, Ms. Collada.
Robert, in reviewing my written motions and when I will stand on the written motion.
No.
The state would stand on its response as well.
Well, I guess you didn't have much of a choice. So the remaining issue is, as I see it, there is a concern that the state's witnesses may testify as to a full investigation, therefore sort of bolstering the testimony of the state's witnesses by going into details of its investigation. The court at this time is reserving that issue and allowing any objections that need to be made if the defense believes that this is happening. It is not the expectation of this court that the state's witnesses will be going into details of an investigation that do not pertain specifically to that witness's testimony. And I'm concerned about the issue that was raised by defense counsel. And so I don't think that this is one of those areas that is so prejudicial that if an element of the investigation is stated and an objection is made, that it would be so prejudicial to the defendant's case. I'm hopeful that if defense counsel believes that any state's witness is going into details of an investigation or steps in an investigation that really are not relevant to that witness's testimony and go to this bolstering concern, that an objection can be raised. I will not hesitate to ask the witnesses to move forward in their testimony, especially considering the scheduling issues in this case. So I hope that that's helpful.
It is, Your Honor. So, and that's not usually the state's practice either, and so I don't have an issue with that.
So any other issues that we need to address today?
I don't, well, I guess it's just a clarification. I know the court's not taking oral argument on the motion to dismiss, so is the court just then making its decision and will let the parties know, or will you see us in court tomorrow? I just want to make sure I know where I'm supposed to be.
I understand that the hearing scheduled for tomorrow at the request of the moving party is stricken, and the court will ask the clerk to strike that hearing. It is very, very, very unusual for this court to draft its own orders and to issue an order on a motion brought by the parties, whether we have oral argument or not. In this case, I will issue a very brief written ruling and allow the parties to draft its own ruling specifying any findings that the parties believe are necessary, or specifying any rulings that the parties believe are necessary to go into greater detail than the court's ruling. Again, I'm not prepared to make a ruling because I haven't reviewed it yet, but I will be issuing a written ruling tomorrow that will be extremely brief, and if the parties require any further clarification, we can address that on the first day of trial.
Understood, Your Honor. Thank you. How much time will we be getting for jury selection?
I don't know. I don't know is the answer in terms of the overall jury selection, because I have a lot of questions that I'll be asking. So I took that to be your question. Will we be completed in half a day?
Or I want to know how much time you're going to give each one of us, so I'll put that in at
20 minutes.
Oh, I see what you're saying.
Don't say 20 minutes. So I will suggest how much time. I'm sorry. I can include that in my suggestion about other.
We'll address that Monday morning.
Thank you.
Yes. Sorry, I misunderstood your question.
Thank you.
So we'll see you Monday morning at 8:30.
Thank you.
Thank you.
Completed for today.